Well, hello and welcome to the Disability Law Show. We're back for another week. My name's John Scholes, Tamar Agopian. Beside me, of course, Samfiru, Tumarkin, LLP. You want to reach out at any time, stlawyers.ca. Phone number, by the way, reach out to Tamar in your own time. Have that chat. She's got a great staff with her as well. To do so, 1-855-821-5900. help@disabilityrights.ca is the email. We'll give you more contact information throughout the show. As we get into this half hour, a busy one, main topic. We talk about this all the time on the show, other weeks tomorrow. That is what to know if you're diagnosed with an invisible illness and applying for LTD. So we'll get to that momentarily. Some emails, some other stuff from our radio shows as well. But we always get warmed up, as they say, pal, with a relatable story, a week that was. What do you got going on?
This week, I received a phone call from a woman that I just had to share her story because it was just something that was so indicative of what people are experiencing, John, day in and day out. And I was actually, let me cut to the end. I'm thrilled that she contacted us. We are going to get retained. We are going to pursue the insurance company. And there's a little twist. I think the employer also has a hand in this as well. So let me describe the situation. She contacted us. She is in her 40s. She's a mom of two. She'd been working for a company for a number of years as a project coordinator. And the reason why the employment aspect is relevant is because she was in the midst of transitioning from working exclusively remotely to gradually returning back to work. You know, we're sort of seeing that come into play on the employment side about the return to work and in office, specifically in office. And so as she was making that transition, the employer had requested that all of their employees by a given date start to go from, I think it was 1 or 2 days to a minimum of 3 days a week in the office. Mm-hmm. In the midst of all of this, she was having a lot of unusual symptoms for which she was being investigated. She had a lot of medical appointments, and she had written to her employer saying, look, I understand the policy, but I really can't manage now with all of these medical appointments and, you know, continuing with this policy. It's not that I don't want to be returning back to work, but I've been doing the 2 days, and it's allowing me the flexibility on the other days to attend to these medical appointments. What ends up happening is, after these medical appointments, John, she sadly gets diagnosed with bladder cancer. I know, it's terrible, given her circumstances, devastating for her, devastating for her family, and not surprisingly, it involves a lot of different practitioners. So it's not just the family doctor that was involved in her care. She also has to see the oncologist, there's surgery on the horizon, chemotherapy, radiation, and basically she's being told, look, we got it relatively early, but it's going to take some time, and we really don't know until we start treatment whether or not even the surgery will be successful and how long this will go for. So in the midst of all of this, she advises her employer and says, look, I'm going to need more time because I've got all of these appointments. Sure. And the employer's advice is you really should just take some time off, take a couple of weeks, and then initiate a disability application. And at this phase, it would have been a short-term disability claim. Fine, fair enough. So she does all of that. And does the insurance company not say to her, well, because you took a couple of weeks off, you do not meet our eligibility requirement, which is that you were not actively at work during the time right before your disability. So for our viewers, let me pause there and just explain this technical aspect of it. In order to qualify for disability benefits, there's all sorts of things that are in these policies. And one of these areas is this actively at work requirement. And we don't talk about it a lot because it's usually a foregone conclusion that you were working right up to the point that you initiate a disability claim. And that requirement in some policies, I should add, will have something to the effect if you've got to work 20 or 25 hours a week at minimum. Most people we know, John, work 37 to 40 hours a week. And in certain circumstances, you know, you're obviously going to have potentially either some sick days or some vacation time built in. So this requirement is not often one that comes into play. And I think what was most alarming in this woman's situation is the fact that it was the employer. Remember what I said, it was the employer who recommended that she take this time and then initiate the short-term claim. And to have the insurer say now that by virtue of her doing that, following her employer's advice, she now doesn't qualify for disability benefits. So she was clever. She did continue to persist. And then the very next letter from the insurance company was, you're not disabled enough. We don't think that you've got symptoms that are sufficiently disabling until you start your treatment that prevent you from working, because you were able to manage these medical appointments while still trying to work. So the takeaway here, John, is that the insurance company is not on good footing and the employer is not on good footing. And these employers will pay premium after premium to the disability insurer for all of their employees to be covered under these plans. And when you have the insurer now resisting not only on a technical requirement that's not quite correct, and then to add the other log on the fire to say you're not disabled enough, when your doctors are supporting that you cannot work, that is the end of the conversation as it relates to the disability insurer, unless there's a legitimate technical reason. And there are, and I don't want our viewers to think that there aren't, but this is not one of those instances. And so when I was speaking to her and speaking to her husband, I said, you have to assert your legal rights in a situation like this, because the employer is not quite doing right by you. They could be influencing the decision with the insurer, and they're clearly not. And now the insurer is resisting your short-term claim, probably because they see the profile that I see, which is this is going to go on for at least a year, maybe more, and she should be entitled to not only short-term disability benefits, but also long-term disability benefits. So my advice is that we start the legal claim, she apply for long-term, and we see this through with the insurer. And I have a very strong sense that everybody's going to be coming to the table and trying to resolve the claim. And the hope is that we can then take this away from her. She can focus on her health, as can her family, and we will take care of this with the employer and the disability.
So she's already at the point where you can step in and help her?
Absolutely.
Wow.
Because she has not only been denied once, but twice. Right. First on the technical reason, and then also on the reason of you're not disabled enough. And what we know, and look, I don't expect our viewers to necessarily know this, but the test to qualify for disability benefits for short-term and long-term, at least at the initial phase of the long-term claim, is the same. It's if you are totally disabled from doing the essential duties of your own occupation, full stop. And surely, if you've been diagnosed with cancer, even if the treatment isn't upon you just yet, but you have all of these symptoms that have required lots of investigations medically and that are preventing you from doing the essential duties, whether it be from a mental health perspective or a physical perspective, and in this lady's case, by the way, it was both those platforms,
absolutely,
then you should absolutely be qualifying for short-term and initiating the process for a long-term disability claim. But you can see that insurers get quite hot and bothered because even if the short-term claim, which usually is payable by the employer, is resisted, then the insurance company doesn't even get to long-term.
Yeah.
They're most likely going to say to her, well, you didn't qualify for short-term, therefore you don't get long-term. And I want to avoid all those excuses, John, because none of this sounds right. She should absolutely be getting her disability benefits, and she should be supported by both the employer and the disability insurer for the duration of however long it takes for her to get better and heal and hopefully get back to work.
Strategically, what do you go after first?
Well, so that's a good question.
Or does it matter even?
Well, so this is something that I think depends on each circumstance. And this is one of the things that we talked to her about and to her spouse about, because she doesn't necessarily want to close the door on employment. And so if she does pursue her employer, there could be some disadvantages in terms of if she comes into a severance amount, for example, would that be a credit against short-term and long-term disability? Usually it is. If you close out your employment, sometimes that also closes the door on extended health benefits. So there are circumstances that we want to consider. And certainly we don't say to people, rush off and start a legal claim in every instance. But this is why making that initial phone call to us, John, is so critical. Because we work in disability law, we work in employment law, we can work through and talk about what the best approach is in her circumstances. And I think if the employer is the payer of short-term, there could be a lot of advantages in actually pursuing the employer in her situation and also tacking on the disability insurer into the claim.
I want to quickly mention a website you can use anytime, pocketdisabilitylawyer.ca. It's a series of, well, tomorrow you can break it down a little further, but it's really handy, simple to use, and it'll answer a lot of your questions as well, right?
It is, and it's a great starting point because it's completely anonymous. It's something that we conceived of a couple years back. It's a drop-down menu, very easy to use, no legal speak, and you can just plug and play information just to see whether or not it makes sense to actually speak with one of us, myself, someone on our team. And if not, that's absolutely okay. You close out your browser, we're none the wiser, but at least it gives you some direction because you can see, even in the information I provided at the top of our show in respect of this one caller, sometimes you just don't know. And the insurers don't necessarily want you to know what those rights are either. So I think these tools are really helpful to try and level the playing field a little bit and give people some guidance, some free advice that they might need as a starting point.
We always tell you as well to keep the emails coming, whether we answer them off air or on air, either on the radio show or the TV show. It's help@disabilityrights.ca. First one for the show. Right now, tomorrow's this. Camille says, my husband was diagnosed with schizophrenia and has been on LTD for almost 2 years now. Our insurer keeps asking for medical updates from his general practitioner, his GP, even though they are not responsible for his medication and treatment. We've asked him to speak directly to his psychiatrist instead. Does the insurer's lack of awareness mean his benefits will be cut off?
Well, the lack of awareness is an interesting part of this email. And Camille, thank you so much for reaching out to us. The challenge that I see time and again is that I see adjusters and insurance companies who don't necessarily understand how these kinds of conditions work and who the right practitioners are to get guidance from. And so schizophrenia is a very complex mental health condition. And I think I'm sympathetic with what Camille is going through, but also give her a lot of credit for redirecting the insurer. She tells us in her email, John, that she has said to the insurance company, look, you need to go and speak to the treating psychiatrist and not necessarily the family doctor about what is happening with his condition. And that's critical because the insurance company, yes, has the ability to write to your doctors and get information. But it's important to remember that while you're receiving those disability benefits, the starting point is actually yourself. You have to initiate some of that to make sure that the insurance company has all of the information that they need. And if you think that there's going to be decisions made around your claim at a critical point, well, that's the time to make sure that your doctors are absolutely involved. Because what I'm not certain of from Camille's email is, how much does a family doctor actually know about the schizophrenic condition? How much is the doctor actually involved in the care and the support provided for the disability claim? And if that particular doctor is not well versed, well, then you're not certain what kind of information, that doctor may provide to the insurance company. And what she also tells us is that, they're at a critical point. He's been on claim for almost 2 years. That tells me that most likely the insurance company is doing a review of the claim and trying to determine whether or not benefits will continue past that 2-year mark, when we see most policies will have a different definition or a different test to qualify. So while all of this is happening, the number one thing is to make sure that all of the doctors are on board. And the close second is to make sure that they're all providing the kinds of updates and information needed to support the disability claim, so the insurance company can't do what I see them do, which is either to cherry pick information or ignore relevant information that's compelling, that's persuasive, that should persist with the disability benefits beyond that mark.
Is there any point to doctors reaching out to you and you guys for advice
Always.
how to craft these things? Because that's not their business, that's not their job.
No, and you know what I'm seeing time and again, John, is that these doctors are overwhelmed. I'm very sympathetic across the country in all the provinces that we work in. They don't get paid for the paperwork.
That's right.
And the insurance companies are obsessed with the paperwork. And so if that's your situation, I think having that good relationship with your medical practitioners is key, because it is very, very difficult to get your disability benefits approved and continuing to be approved if you don't have that paperwork in place. And so if they need to speak with us, that's absolutely fine. I invite those kinds of conversations. I of course, never want to get in between, a patient and their doctor, but we understand what insurance companies are looking for in terms of information. We actually have a really helpful memo on this at ltdfaq.ca. Right. And so lots of resources for people to go after if they're trying to figure out, how do I best position my disability claim when they're at critical phases like this, when the insurance company is going to make a decision on whether or not to cut off the claim.
Good start. Lots more to go. Main topic as well. You got an invisible illness and you're applying for LTD. We'll tell you how to navigate that, what you're in for in that regard, and lots more. The Disability Law Show is coming right up. Stick with us. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you. They may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. we know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca.
Okay, we're back at it. Disability Law Show continues. Tamar Agopian, anytime reach out to Tamar and her team. Sometimes it's a conversation or an email you want to send on your own time. It's 1-855-821-5900, help@disabilityrights.ca. And we always do a main topic every show as well. Super helpful. What to know if you're diagnosed with an invisible illness and applying for that LTD. This can be a rocky road, but some of this will be cleared up right now, Tamar. Number one, invisible illnesses are typically difficult to diagnose due to what we always talk about, the lack of objective medical evidence, right?
Well, and the objective medical evidence, I'm all over it, but I actually want to take a step back on the diagnosis part first. This is where I want to start, John, because this is a big myth in disability litigation, that you need a diagnosis in order to qualify for disability benefits. And that is not the law, folks. The law has supported that if you have symptoms, and those symptoms are sufficiently disabling to prevent you from doing either the essential duties of your own job or the essential duties of any occupation, then you do qualify for disability benefits. But because we've got a whole host of adjusters who have very little medical training, and they've got a job to do, and they've been told that that job requires them to paper their file, they will search for the diagnosis, and they will search for the kind of medical information that they think is quote-unquote objective. Now, how can you have an objective test when you've got conditions like chronic pain, or fibromyalgia, or a brain injury, or a mental health condition? We call these invisible diseases. I don't even necessarily like that term, but certainly diseases and conditions that have symptoms that can't be tested in the way that a broken arm can be tested, that can't be tested or at least proven, quote unquote, in the same way as disabilities that are more straightforward and typically more physical in nature. And because these kinds of disabilities are outside of the sort of four corners of what these adjusters can manage, you get a lot of resistance from disability insurers in terms of approving these kinds of claims. And John, they're using like a WebMD kind of resource, right, these adjusters. So they're putting in fibromyalgia, and it's giving them a very general picture of how fibromyalgia is treated. And some of the literature says you should keep working and stay active. And so I've actually seen quotes like this in letters to insureds denying claims when either they say it's not sufficiently supported, or even if you've got this condition, you should be able to still work. And so this is why it's really frustrating that people sometimes will sit back and say, okay, I guess the insurance company must be correct, and maybe I should just keep working, even though my doctor is saying that I shouldn't. And so the challenge here is that you want to make sure that not only your treatment efforts are documented, but also those symptoms that are preventing you from working are also documented, more so in these kinds of invisible illnesses than any other kind of condition.
Point number two is this: disability insurers often deny those LTD claims due to insufficient medical evidence. Of course they do.
Of course they do. And this dovetails nicely with what I was saying earlier, which is when you're on claim with a disability insurer, or you're trying to start that claim out of the gates, it is critical that you have as much information about what is going on with your health available to the insurance company. That includes the forms that you have to submit. It could include reports or clinical notes and records from everyone and anyone who is treating you. Just because insurance companies like to, cherry pick information or use excuses like this that, well, there's just not enough information to persuade us to pay your claim or continue paying your claim, doesn't mean that you don't have a valid disability. It really is the starting point of, if your doctor maintains that you can't work as a result of your health, regardless of a diagnosis, regardless of what else is happening or what the insurance company is saying, you're absolutely entitled to those benefits. And insufficient medical information is actually a relatively quick fix, John. We have lots of claims like that where people have been denied on that basis, and we've been very successful in getting the insurance company to the table, and sometimes even working with practitioners to get the right kind of information available to support that disability claim.
We were talking about applying for LTD when you have what we call an invisible illness, right? Number 3 is this, Tamar, with the support of a treating doctor or specialist or doctors, you can and should still receive those LTD benefits, of course.
I can't emphasize this enough, how critical it is that it is your own doctors that really dictate what should be happening with your disability claim. Again, much like I said at point 1, the courts have supported that symptoms can be disabling without a diagnosis. And courts have also deferred to your own practitioners. Your own doctors will be preferred over the ones that the insurance company would like them to use or rely upon. And so when you're in this situation and you have the support of your treating doctor, that should be enough, in theory, for you to get your LTD benefits approved and supported, whether it's through a legal claim, whether it's through, the adjudication of the claim. But John, it requires some effort, and I recognize that. And I think that the challenge that people face is that if they're not really sure what's happening with their health, and maybe their doctor isn't really sure what's happening with their health either, that puts them in a situation where they can't be very firm or feel as though they can't be very firm with the insurer about what's happening with their patient. But that's not necessarily the end. I think that doctors could also make referrals, even just making a referral to a specialist, even if the family doctor doesn't know what's happening. That in and of itself could also support that there are symptoms there that this patient is experiencing that support the disability claim and that require further investigation. So again, it's all about the starting point of your own treatment providers, making sure that information is available, making sure it's detailed, and making sure that the insurance company has all of that right from beginning to end when you're dealing with them. And if you're still being met with a barrier after barrier, well, I wholeheartedly think that the legal claim is the answer. You absolutely should be contacting a disability lawyer in a situation like that, because we deal with these kinds of claims all the time. And as I've said a few times over, the law is on our side. So why not allow us to leverage that against the disability insurer to get those benefits paid?
You bet. A topic well covered right there. We did mention off the top of the show there's several different ways to reach out to Tamar and her team. MyDisabilityQuestions.com is a good one. We'll get to a question from that on the other side of the break. So stay tuned as we continue more of the Disability Law Show.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
All right, thank you for hanging in with us here on the Disability Law Show. I want to remind you can reach out to Tamar and her team anytime on your own time for a private conversation. How about that? 1-855-821-5900 for the phone. Email help@disabilityrights.ca. And this website, mydisabilityquestions.com. It's anonymous, so feel free to use that anytime you would like. Oliver is up in that regard. Tamar says, with the support of my doctor and physiotherapist, I had to stop working after shoulder replacement surgery a year ago. My case manager has told me to change to another physiotherapist and specialist they recommend. Do I have to follow these suggestions? I've seen real improvement with my own medical physicians.
Oh, this is such a challenging one, John, because I sympathize with Oliver. He has described to us that he has seen so much improvement with his own treatment providers, and now the insurance company kind of wants to pull the rug from under him. And why do they do this? So actually, that's my first question. Why are they doing this, Oliver? Ask them that question. Why are they doing it when you're seeing so much improvement with your own treatment providers? Is it because they're getting ready to do a plan that's more return to work focused? Or is it because they want to have you assessed? Or is it because they want to supplement your treatment, perhaps, with some other element of treatment that they think is going to be the magic bullet? I would get some clarity around that first, because you always want to be wary of the insurance company's motives when they're saying to you, yeah, we don't want you using your own treatment providers. This rehab facility is great. Or this specialist. I'm surprised they're even suggesting some kind of specialist. John, I'd want to know who that is and why. Because really, at the end of the day, if you can have these treatment providers be the ones who your doctor recommended, or that's being supported by you or funded by your own extended health benefits, that is always preferred over the one the insurance company is recommending. Because the insurance company is paying for this treatment. If they're paying for the treatment, these treatment providers are not going to be on your side. They are not what we call arm's length. They're going to be influenced by the disability insurer, and they may have a very specific directive of saying, look, we're going to fund 8 weeks of treatment, and at the end of that, we expect you to sign off and say that this individual can return back to work, and be really aggressive about it. But to get to the heart of what Oliver has asked us, John, is, do I have to? And there are creative provisions in these disability policies that, they have rehab terms that say, if we think you need certain treatment, or if we put a program in place, you must attend that program. And what I don't like about the must is that it doesn't necessarily take into consideration Oliver's health and Oliver's best interest. So what you want to really determine is this reasonable? Is it necessary? Is it treatment that can be offered by your own providers? And if not, you want your doctor to weigh in on this. You want your own doctor to comment around, look, thank you very much, insurance company, but we think this is going to do more harm than good. Or if it's a super aggressive plan, it's going to unravel everything that we've done so far. And thank you very much for your specialist, but I'm going to send my patient to such and such individual, and we'll let you know how it goes at the end of that. But again, it's active engagement by your own medical team. This has been the theme throughout our whole show today, John, is that if you don't have that, you're going to find yourself in a situation where the insurance company gets to impose their will, they get to impose the policy, and use the policy as a means of cutting off benefits, or saying to you, because you didn't comply with whatever we wanted, we're not going to continue paying those benefits. Yeah. So you've got to be really, really careful when you try and navigate this. And if you've got any questions, we're only a phone call away.
Let's get Emily's email in here quickly, last couple minutes. I think Candace says, I've been on LTD for almost 2 years and was approved for CPP Disability earlier this year. In a call with my disability insurer, I was told that they are reviewing my case again to decide if coverage will continue, should continue. If CPP Disability has approved me for long term, can the insurance still decide to cut me off?
Look, Emily, unfortunately, yes. Unfortunately, even if CPP has been approved, your LTD insurer is going to look at a different test, their own policy, and make their own decision on whether or not your benefits are going to continue. But they shouldn't. If you're CPP approved and you get cut off, please give me a call, because that CPP approval is excellent leverage against the insurance company. In my view, the CPP test to qualify is severe and prolonged disability. Very high bar to beat, and if you've met that and the insurance company is still saying you're not totally disabled, then guess what? I think they've got it wrong. And so even though it's two different processes, one is with the disability insurer and the other one with the government, the test to qualify can be very persuasive one to the other. So you want to be careful, you want to go through that process, but you want to make sure that you're getting your rights engaged by the right lawyers if, in fact, the insurance company says that you're not eligible even after you've been approved by the government. And
if you do get cut off, you're still getting CPP money, so it's a good thing. It is.
It is a win, because those CPP disability benefits will continue regardless of what the disability insurer does on LTD.
And we are up against the clock. Thank you so much for your contributions to the show. You want to carry on that conversation with Tamar now that we're done for this week? Do so. Phone number 1-855-821-5900 or email help@disabilityrights.ca. We'll catch you next time.